Now, I'm not one to gossip, but I will bring you the tea. Welcome to Chronicle Speaks.
Please, I don't have any time for any gossip now. Eh? Yes.
Look at you.
So Diddy's trial is just over 2 months away, and as usual, his legal team is pulling out all of the stops in hopes of getting their client out of this tight spot. Now, we all remember the searches conducted at 2 of Diddy's homes last year, one in Miami and the other one in California. Now, during those raids, federal agents confiscated a lot of items, including his computers, his phones, his cameras, his baby oil, whatever you name, they got. Well, now Diddy's legal team is challenging the search warrants that federal agents used to raid his homes and examine his internet history. They're claiming that the feds made false statements in their applications for these warrants. Now, his team filed a motion to suppress the evidence, arguing that the government presented a grossly distorted picture of the facts when they obtained these warrants. Now, we're also going to talk about attorney Tony Buzbee, who is making headlines after being barred from practicing law in the Southern District of New York. Now, unfortunately for Buzbee, that's where most of his cases against Diddy were located. According to documents, the decision to bar him stemmed from his failure to obtain the necessary permission before submitting his application for admission to the district court back in January 2025. Now, this procedural misstep, coupled with allegations of misconduct during his filing process, prompted the Committee on Grievances for the Southern District of New York to take disciplinary action. So what does this mean for his cases against Sean P. Diddy Combs? We're going to find out just that, but before we do, please be sure to subscribe to this channel and hit the bell for notification so you don't miss out on any news regarding this story and so much more. Now let's get back into it. Now, as of late last week, Diddy's team is down one top attorney. Defense attorney Anthony Rico abruptly requested to withdraw from Sean P. Diddy Combs' case. So on Friday, attorney Anthony Rico submitted this letter to Judge Subramanian. On September 22nd, 2024, I was retained by the defendant, Sean Combs, to serve as his counsel, and I have served as his counsel since that time. As a result of being retained, a notice of appearance was filed in our court on September 29, 2024. This declaration is submitted in support of the annex notice of motion for my withdrawal as counsel, as is required under the Southern District of New York local court rules. For the reasons set forth below, this motion for withdrawal is filed so that Sean Combs may move forward with his defense and to commence jury selection and trial without any delay. Reason to be relieved as counsel for Sean Combs: number one, as a result of discussions with lead counsel Mark Agnifilo, this motion for withdrawal of counsel is filed. While I am aware that the local rule requires that an application of withdrawal of counsel is supported and granted only upon a showing by affidavit or otherwise of satisfactory reasons for withdrawal, there are sufficient reasons related to the protections afforded by the attorney-client privilege for brevity in my application for withdrawal as counsel in this case. Although I have provided Sean Combs with a high level of legal representation expected by the court, under no circumstances can I continue to effectively serve as counsel for Sean Combs consistent with the ABA standards for criminal justice. This motion for withdrawal of counsel, if granted, will not result in a delay of his present schedule for the commencement of jury selection and trial or the present schedule for briefing or pretrial legal issues. As a result, there will be no lapse in representation as Sean Combs will continue to be represented by 5 other attorneys of record without violating any aspect of the attorney-client privilege or otherwise providing any details whatsoever on the grounds supporting the application. The government has been notified of the filing of the motion to withdraw as counsel. The government takes no position on the motion seeking withdrawal of counsel for Sean Combs. Wherefore, it is respectfully but regrettably requested that the court grant the relief requested in the annex notice of motion and permit counsel Anthony L. Rico to withdraw as attorney of record. In my opinion, attorney Anthony Rico saw the ship wrecking and decided to abort mission before they took him down with him. And you have to think about it. Anthony has seen evidence that we have not, which is obviously the reason why his attorneys are trying to suppress said evidence. Diddy has an uphill battle while trying to have 1 foot and 2 toes. It doesn't seem like he's going to make it, and working alongside the attorney that seems slower than a parked car, the one that stated that Diddy bought his baby oil from Costco in bulk, prompting Costco to come out and say, we don't even sell baby oil. Mr. Rico, I would probably quit too, because what you're not going to do is ruin my reputation while losing this case. Next, now let's talk about attorney Tony Buzbee. So Buzbee has been making headlines after it's now being reported that he is barred from practicing law in the Southern District of New York. Now, as you may or may not know, most of Diddy's cases are located right in the Southern District of New York. Now, Buzbee is probably one of the most notable attorneys spearheading the takedown of Diddy, being that he had this 1-800 press conference talking about his 120 clients, half male, half female, and a few of those clients were children at the time of the SA. Buzbee has appeared on TMZ, interviewing wherever he could. Well, one place he forgot to stop while making his rounds was the Southern District of New York's courthouse. There he would have filled out his application to appear pro hac vice in this particular district. He did not. So on February 13th, the Committee on Grievances considered Anthony G. Busby's petition for admission to the United States District Court for the Southern District of New York. Now, this petition was filed on January 29, 2025. Now, per the committee's review of the docket, Mr. Busby has appeared in cases in this court without seeking admission. Therefore, the petition is denied. In the event Mr. Busby moves for pro hac vice or regular admission in this court in the future, he must attach a copy of this order to his motion or petition. So that's what he did on Friday, February 21st. He filed a motion for admission pro hac vice. It says, pursuant to Rule 1.3c of the local rules of the United States District Court for the Southern and Eastern Districts of New York, Anthony G. Busby hereby moves this court for an order for admission to practice pro hac vice to appear as counsel for plaintiff Candace McCrary in the above captioned action. He continues by saying, I am in good standing of the bars of the state of Texas and New York, as well as the Eastern District of New York. One grievance was recently filed against me in the Southern District of New York, as explained in the attached affidavit, but otherwise I have not been the subject of any disciplinary proceeding. I was recently denied admission to the bar of the Southern District of New York, based in large part of the grievance referenced above, as explained in the attached affidavit, but otherwise have never been censored, suspended, disbarred, or denied admission or readmission by any court. I have never been convicted of a felony. I have attached the affidavit pursuant to Local Rule 1.3. So again, he admits to being in good standing with the bars of the state of New York and the state of Texas and the Eastern District of New York, but nothing about the Southern District of New York, which is where he was practicing representing the clients against Diddy. Now, Tony Buzbee showed proof that he is in good standing to practice law in the state of Texas and also in the state of New York. He also showed proof that he is in good standing with the Eastern District of New York. However, in federal court, attorneys must be admitted to practice in the specific district where they intend to appear. Without admission, an attorney cannot file documents, they cannot make appearances, or engage in any other legal activities within that district. So he's been acting as such in the Southern District of New York, and he got caught. Dude, you can't do this. And you filed case after case after case. So right now he has filed the necessary paperwork and he's waiting to see if it will be granted. So Buzbee proposed this order last night and he's waiting for the judge to approve it. So it has not been approved yet, but he says this motion of Anthony G. Buzbee for admission to practice pro hac vice in the above captioned action is granted. Applicant has declared that he is a member in good standing of the bars of the state of Texas and New York, as well as the Eastern District of New York. And his contact information is as follows. Applicant having requested admission pro hac vice to appear for all purposes as counsel for plaintiff Candace McCrary in the above entitled action. It is hereby ordered that applicant is admitted to practice pro hac vice in the above captioned case in the United States District Court for the Southern District of New York. All attorneys appearing before this court are subject to the local rules of the court, including the rules governing discipline of attorneys. So there is no judge signature. It's not dated. The attorneys just enter this for the judge to simply sign and move on about their business. It hasn't been granted yet. So let's speak about the main event. So Diddy's attorneys just recently filed a motion seeking to suppress evidence that were found in Diddy's homes, on his person, in his phones, on his computers, and much more. Now, in this document, Diddy's attorneys are stating that the government is required to be honest and thorough when it seeks warrants to search someone's property. Now, in cases like this, the process is not adversarial, meaning there's no back and forth between both sides. So investigators must present all relevant facts, both for and against their case, meaning they can't leave out information that can weaken their argument for why a warrant is needed. And in this case, they're stating that the government didn't do that. It misrepresented the facts when seeking warrants to search Mr. Combs' homes and electronic devices, presenting only information that made him look guilty and leaving out crucial details that could have helped the defense. For example, they stated that the government did not mention that some of these supposed victims appear to have participated willingly in the events, i.e. the freak-offs, and they also failed to mention the text messages between the victims and Mr. Combs that could have been exculpatory. They're also stating that the warrants were overly broad, allowing the government to search through large amounts of his personal information, which included devices, his iCloud accounts, and different things that weren't specifically linked to the alleged crime. They believe that this type of search is unconstitutional because it gives the authorities too much power to invade a person's privacy without clear limits. Now, they seem to really be upset that the government's warrant application did not mention that the key witness, Cassie, had a financial motive to exaggerate or even lie about her claims. They're stating that years after her relationship with Combs ended, she changed her story in a way that would cause the most harm and possibly pressure him into making a large settlement to her. They're saying that this kind of motive directly affects her credibility and that the law says that any evidence undermining the credibility of a key witness must be disclosed. So by failing to include this crucial information, the government misled the magistrate judge, which made the warrant application unfair and misleading. Needless to say, they're saying that the government in this case acted with a damn the torpedoes attitude, pushing ahead with the prosecution without properly following the law. They rushed to gather evidence and misrepresented it in a way that misled the judge, preventing an honest evaluation on whether there was enough reason to conduct a search. Now, they only presented evidence that made the defendant look guilty while hiding the evidence that could prove his innocence. The incorrect evidence they used was critical in justifying the searches of the defendant's homes and digital devices. So in conclusion, Diddy's team says this: for the foregoing reasons, this court should suppress the evidence and all fruits obtained from the warrants to search Combs' residence, his person, and his iCloud account, and his devices. These warrants were unconstitutionally broad. In the alternative, and at a minimum, this court should order a Franks hearing to hear additional evidence and determine whether the warrants were improperly obtained through deception. Now, I don't even know why they tried it, but they do get an A for effort. With knowing the type of judge that Judge Subramanian is, he's not going for this. I honestly feel like Diddy's attorneys are throwing anything against the wall to see if it sticks. They are down one attorney. The evidence is definitely not working in Diddy's favor. Then the woman that Diddy dated for all of these years, Miss Cassie, who said that Diddy abused her, and he said she was lying and only wanted money, and that wasn't true. Then a video came out showing that he did, is the key witness for the prosecution. Diddy is done. But what I need to do is hear from you. What do you think about everything going on in the world of Diddy? Leave a comment and you know how we do. We'll talk about it down below. Talk to you guys later. Bye. As always, thanks for watching. But before you go, don't forget to subscribe to this channel, hit the like button, and hit the bell so you don't miss out on any of my new episodes.